These parties spent several months attempting reconciliation, which is part of the reason why this case has been on file for as long as it has. This morning, Ms. Locke and I discussed scheduling a structured settlement. The parties have exchanged settlement offers. They do not agree on them, obviously. Otherwise, we'd be here to put a final divorce decree on the record. But they are much closer than they have been. But there were several months where they worked on reconciling, which I think it's important for the court to know that they had attempted to not proceed, and that failed. But that caused quite a significant pause in the case as well. And then I do want to put on the court's radar that there is a procedural issue that I need to raise if we're going to proceed on this contempt.
We are going to proceed on this contempt. Ms. Levitt, what is the procedural issue that you raise?
Your Honor, for when a contempt is filed, it is required by statute KSA 20-1204A subsection B that the order to appear and show cause shall be served upon the party allegedly in contempt by the sheriff or some other person appointed by the court for such purpose. In this case, this contempt was not served on my client by the sheriff or a process server. The return of service shows that it was mailed to my client using certified mail, which is not allowed for under the statute. So although my client is here and present, it's due to the other motion that was filed. The service is not correct on the contempt, and the statute is clear. It says shall be served by a sheriff or process server.
What other motion are you referring to?
Your Honor, Ms. Locke had filed a motion as to some discovery issues. There was a motion to compel and a request for inspection.
So your appearance, your client's appearance on the contempt is a special appearance to challenge jurisdiction.
Yes, Your Honor. The statute is very clear as to how service has to be done, and it was not complied with.
Ms. Locke, I believe
this case has been on file for months as the parties tried to reconcile. Despite efforts, reconciliation failed, causing significant delays. Today, we turn to settlement discussions. Ms. Locke and counsel exchanged offers but haven't agreed, which is why a final divorce decree isn't on record yet. The court notes a procedural issue with a contempt motion. The service wasn't done correctly by a sheriff, as required by statute. While serious issues exist, the court cannot move forward on contempt. Instead, the focus shifts to discovery matters, ensuring privacy and fairness for both parties moving forward.
I believe that is a requirement in this case. Why wasn't this served by the sheriff?
Your Honor, if it was not served by the sheriff, that is an error on my part. My understanding is that it was sent for sheriff service, but if it was not, that I agree is an issue.
It's an issue that precludes the court from going forward with the contempt citation at this time. The court finds that there was improper service in this case, that the court does not have authority to go forward on the contempt citation at this time. With that said, there are some serious issues raised by this contempt citation, and I would sure hope that the parties in this case would recognize the privacy rights of the other. Nevertheless, the court will make no contempt finding at this time, and we'll move on to what appears to be the other motion before the court, and that apparently deals with discovery issues. Ms. Locke, you may proceed further in regards to that.
Thank you, Your Honor. We have, as I stated to the court earlier, and just for a little bit of clarification on Ms. Levitt's position,
Ms. Locke clarifies her client disagrees reconciliation occurred. The respondent has been clear she wasn't interested. Meanwhile, discovery has been ongoing. Tax returns have been provided, but cryptocurrency remains unresolved. The petitioner claims Ethereum was held in a Robinhood account, now sold, yet documentation is incomplete. Issues persist due to incomplete cooperation. Both sides need proper documentation to value marital assets, including cryptocurrencies and toy collections. Ms. Locke requests inspection of the Lego sets for expert valuation. The court hears arguments over the credibility of the lists provided, emphasizing the importance of accurate and timely responses in discovery.
Disagrees with the idea that the parties were attempting to reconcile. She has not been interested in reconciling, and has not been, and has made that very clear to the petitioner in this case throughout the case. However, we've issued discovery twice in this case, as well as a request for inspection. I cited in my motion that we didn't have the petitioner's tax returns. That issue has been resolved. I also had concerns about cryptocurrency. That issue has not been resolved. There was a statement to us that the cryptocurrency has since been sold. However, we have no affirmative documents related to the cryptocurrency. The petitioner has been played some sleight of hand with the cryptocurrency, says he has documents but doesn't have documents, says we could get them but he can't get them. So we have challenges with that. He is very tech savvy. We would like the documents related to the cryptocurrency to value them.
Ms. Levitt explains the Ethereum account was disclosed via Robinhood with $600 reported. The account statements show activity only when downloaded, limiting historical access. No Bitcoin exists, contrary to claims. Lego collections, mostly Star Wars sets, were catalogued with serial numbers and values from Lego.com and eBay. These are not rare collectibles, yet inspection is requested to assess their worth professionally. Ms. Levitt emphasizes prior opportunities for inspection, noting the respondent has accessed the home multiple times. She argues that valuation requires a qualified expert, not merely party opinion. The court considers whether photographic documentation or an on-site expert is best.
As a marital asset. Additionally, the parties have some pretty significant toy collections, an RC car collection, which I believe has been agreed upon, but also a Lego collection. We asked and submitted a request for inspection related to the Lego collection. There was no response ever provided related to our request for inspection. And so that is part of our motion to compel here today to allow us to get the Lego collection inspected and valued as a marital asset.
All right, Ms. Levitt.
Thank you, Judge.
Your response?
Yes, Judge, and I know that this is not the issue, but I just do want to tell the court on the reconciliation, these parties went to marriage counseling for weeks. So that wasn't for reconciliation, then I guess that is what it is, but that's why my client believed they were working on reconciliation. As to the discovery issues, the cryptocurrency that my client owned is called
Ms. Locke states her purpose is to photograph the collections so an expert can assess value, not to personally assign worth. Delays arose because the petitioner never responded to the inspection request submitted months ago. Starting with a low-cost, reasonable approach seemed appropriate. She is willing to coordinate with an expert on-site for proper valuation. The court stresses the need for quick action, warning the case cannot languish further. Both parties must cooperate fully, including scheduling around the expert's availability. The respondent works from home and will adjust to allow the inspection, emphasizing professional collaboration to resolve discovery efficiently and fairly.
It is held through a Robinhood account. I am looking at an email that was sent with all the discovery responses as digital attachments to Ms. Locke, in which the Robinhood account that holds the Ethereum, $600 worth of cryptocurrency, was sent as part of discovery responses. We have responded in a follow-up letter that Ethereum is cryptocurrency. It is held in the Robinhood account. That is what Robinhood is. It's like E-Trade is for stocks, Robinhood is for cryptocurrency, and that is all the cryptocurrency that my client is in possession of. The way Robinhood does their statements, Judge, is you are advised that you can have a statement available for download each month. If you go in and download it, then you have the statement. If you don't download it for that month, you cannot go back to prior months to download it. So I've advised that Ms. Locke, she can send a business record subpoena to Robinhood and see what she can get. My client had statements from when he had opened the Robinhood account, and then he had a statement from the month when discovery was received. That is all the cryptocurrency he owns. They have repeated
The court addresses cryptocurrency documentation. Ms. Levitt explains her client has gathered all accessible information through Robinhood. If additional records are needed, a business record subpoena may be necessary, likely issued by the respondent. Ms. Locke explains the October 2024 statement doesn't reflect the date of separation value or proceeds from the sale. These details are critical to the case, especially for determining marital estate assets. The court orders that if a subpoena is necessary, it must be submitted within 30 days. The aim is to ensure all relevant financial information, including cryptocurrency transactions, is accounted for properly before final settlement or trial.
Repeatedly ask about him owning Bitcoin. We have answered that he does not own Bitcoin. He's never owned Bitcoin. Quite frankly, I think that this is an attempt by the respondent to allege that my client is hiding this money that doesn't exist. And they want us to prove something that you can't prove a negative. I can't prove that there is no more cryptocurrency than the Robinhood account. We have handed over the Robinhood account. As to the request for inspection, a Lego list with all of the all of their sets they put out, Judge, have like numbers. They put serial numbers on them. So a list with all the serial numbers, the name of the Lego set, the value of it off of the lego.com website and off of ebay.com for older sites has been sent to Ms. Locke. I advise that if she had someone who was able to value a toy collection or a collectibles like Legos, that we could make the items available for inspection. But if it's merely the respondent wishing to come into the marital residence and dig through my client's Lego collection, these parties were married for a very long time.
Regarding other discovery, Ms. Locke clarifies she has no further requests. The court emphasizes that the goal is to determine what is necessary for resolution, not to track every dollar spent since separation. The focus is on assets affecting the marital estate. The court also sets a 30-day window to complete outstanding discovery, ensuring the case moves toward either trial or final settlement. Both parties have agreed to attempt mediation to narrow issues or reach resolution. The court suggests retired Judge Powers as mediator, aiming for mediation within 45 to 60 days, factoring in pending matters such as cryptocurrency subpoenas.
She bought many of the items and gifted them to my client over the years for birthdays, Christmas, those things. She has been at the house 3 times by agreement to pick up property and to go through the party's personal property and divide it. She's been at the house several other times, entering the garage without consent to go through personal property and take items. She has had plenty of opportunity to view these items, besides the fact that she, throughout the marriage, was one of the people who helped my client receive those items as part of his collection. We do not oppose an inspection, but I'm not sure what the respondent's ability to value that collection is if she sees them themselves versus receiving the list of the items. And I think that if we're calling this a collection, if there is some issue or concern by the respondent that these are collectibles worth more money than what they were purchased for. For example, if you were to talk about somebody who collects like rare baseball cards, then the respondent is not qualified to make an assertion of that value. It would require somebody who runs like a comic book store, somebody who's within that collecting world who, as part of their profession, values those collectibles to say this is the value of the item. The respondent herself would not have the prerequisite knowledge to do that. And so, quite frankly, I don't know what information they're seeking other than to say they want to know about the toy collection. Well, they know about the toy collection. They know it's Legos and RC cars. They have an entire list of all the serial numbers. If they believe they're valuable collectibles, which they are not, Judge, I do want to be clear on that. My client is a big fan of Star Wars and he likes Legos. And so he's purchased a lot of the Lego Star Wars sets. He's been gifted a lot of the Lego Star Wars sets. They average about $29.99 a set. They are not rare collectibles. They're not hard to find. They're all over eBay, which is why the list was created as to what their value was. But if she believes that they are worth more than what they are sold for online, then she needs someone who is an expert in that world to make that determination, not her.
Ms. Locke, do you have a valuation expert in mind to inspect these toys and to give a fair estimate regarding their value?
Your Honor, our request for inspection specifically states that we be allowed to come in to picture the collections so that they can be valued by an expert in the field. So we have not secured an expert, and obviously we would be required to do disclosures for that, but the purpose was not for us to come in and my client decide what the values are. The request for inspection specifically asks that we be allowed to photograph the Lego collection so that we can then go and have it be valued. Additionally, Your Honor,
Can an expert do it purely from photographs without being able to see the items themselves and their current condition?
Your Honor, I think that would be at least a good starting point for us. Again, I just want to give a little bit of backstory here. We issued discovery in 2024. We issued a second set of discovery early in 2025. We had to file a motion to compel to get responses to our second set of discovery. Ms. Levitt talks about this list that she provided us of all of these Legos. I got that list at 4 o'clock on Friday. Today's Monday at 10 a.m. So the idea that we've had all of this information and we could have done all of this stuff is just not accurate. I received her document at 4 o'clock on Friday for this hearing at 10 o'clock today, when the request for inspection was in early May. And so there was plenty of time to respond and say, hey, here's the list. What more information do you need? But instead, we're getting this information as a result of us having to file a motion, which is improper. The discovery in these items should be forthcoming. And it should be, Mr. Roberts is not qualified to value a Lego collection in the same way that my client is not qualified to value a Lego collection. So we thought starting with the easiest, most low cost option would be viable to let us come in. Again, we specifically requested the opportunity to come to the house rather than just showing up at the house, to come in,